continue our interview with the chairman of the Anti-Monopoly Committee of Ukraine. Mr. Terentyev, Ukrainian antitrust legislation has been heavily criticized by the Western lawyers, by some of the Ukrainian lawyers, by the European Commission as being overly conservative. I understand that currently there are at least 2 draft bills in the Ukrainian parliament aiming to change that, namely to raise the merger control thresholds. Can you tell us the position of the AMC on these 2 draft bills and when we can see the law being adopted as a law?
Despite the fact that our competition law and on the level of principles is in line with the best standards of the developed countries, there are still some areas which require improvement. And mainly the necessity for improvement is in the areas of practical law enforcement, transparency of activity of the Anti-Monopoly Committee, and namely in the merger control area, what you have mentioned, because indeed in fact, OECD review of Ukraine's legislation in 2008 recognized that the major thresholds which were in the law on protection of economic competition, they were ineffective because they catch way too much transactions and they overload our competition authority with way too many files, which eventually do not allow us to focus on the right topics. So there were a number of drafts dedicated to this issue. Also, Anti-Monopoly Committee proposed an option. No, actually, we have developed our vision of what is the appropriate system of thresholds, and at the same time, there are several groups of members of parliament which were also working on these same topics. We worked together with Victoria Ptashnik, and our position is we had a number of working meetings, and our position is fully aligned with her now. So she listened to our proposals, she incorporated some of the ideas which we proposed to her draft, and for the time being we support the draft which is currently in the parliament. However, there is a number of other drafts, but we believe that the draft in which we work jointly would address the problems which everybody expressed in the most effective way. Again, Mr. Terentyev, talking about the timing, when we can see the draft becoming a law? This I cannot comment because Anti-Monopoly Committee can support professionally with some expert opinions the draft, but where a draft is going to be approved by the parliament is a question to the parliament.
Understood. Mr. Terentyev, in 2012, the AMC, I understand you were not the chairman back then, but the AMC opened an investigation into the alleged cartel case against the largest retail chains here in Ukraine. And in May of 2015, the AMC issued a fine which was heavily criticized by the Ukrainian business and legal community because what the members of the cartel claim is that the activity which they were accused of is totally acceptable under the EU competition law, and this is a market practice. And when the AMC imposed the fine, this was caused an uproar in the business community, where they accused the AMC of not following the market standards. What is your personal position on that case, and do you agree that the imposition of this fine was a bit off the market course, and what are you planning to do with this case?
Currently, these decisions was challenged with the court. All the retailers filed lawsuits to render invalid the decision. And in this particular, under this particular circumstances, I would say that the most appropriate way would be that the court should really assess the findings of Anti-Monopoly Committee and the position of retailers, and really have an impartial view on this case.
But how do you respond to the accusations that the AMC is taking non-market approach in this case, has taken the non-market approach in this case?
In fact, the decisions which Anti-Monopoly Committee was working for about almost 3 years on these files. And the files are really huge, I mean, in terms of volume and in terms of primary evidence collected. The main element of accusation from the side of Anti-Monopoly Committee was and remains that there was a sort of disproportionate information exchange between retailers which was organized via a marketing company. Marketing company in turn is saying that basically what it was doing in terms of service to the retailers was in line with international practices, and it was not anti-competitive but pro-competitive in its essence. However, Anti-Monopoly Committee assessed that before, the view of Anti-Monopoly Committee was that the volume of information provided by the marketing company to the retailers was excessive. And in parallel, it coincided with the increase of prices generally in the market. In order really to, it took 3 years for the previous Anti-Monopoly Committee to get to these conclusions. Myself, I'm in this position since 19th of May, and the panel of commissioners was just appointed in the very end of July. To really reconsider fully this case on the level of assessment of every element of primary evidence would take us maybe 4 to 5 months. So therefore...
Yeah, but Mr. Terentyev, the market players are saying that such behavior of the Anti-Monopoly Committee of Ukraine will scare off foreign investors, which say that back in their home countries, because some of the retailers were foreign-based companies, and they say that in their home countries, which in the EU member states, such activity is totally fine and totally acceptable. And here in Ukraine, where the country is aspiring to become a member of the EU and trying to align its legislation with the EU norms, this is not fine, and they're being fined for that.
What I may say on this is that I understand that you can hardly find a sector where in economy where the competition is as intense as in the retail sector. However, even in European Union, from time to time, almost on a yearly basis, there are cases where companies, having in mind a good intention, do something wrong, I mean, which gets interpreted by anti-monopoly committees of the respective European countries as infringements of competition law. So I know that companies in the retail sector, they work in a very competitive environment.
So basically, you don't think this will scare off investors?
What I say that we promise unbiased, objective review of this case. We in parallel we will rethink, so to say, the approaches which Anti-Monopoly Committee employed before in order to plan our activity for future. But the cases on the decisions which have been taken, I anticipate that most likely they will have to be decided by the court.
Understood. Mr. Terentyev, my final question. Before the war in eastern Ukraine began, there was a very tight, close cooperation between Ukraine's antitrust authority and Russia's antitrust authority, FAS. Including, there was a very extensive exchange of information, including about the owners of the companies from both countries. What is the situation like? What is the situation like right now? Does the AMC still exchange information and works closely with the FAS, or this has stopped?
We have no interaction. We have no interaction with the Russian Federal Anti-Monopoly Service.
And this has stopped recently because of...
This has stopped not really very recently, but when there were due reasons for that.
Understood. Well, looks like we won't be having exchanges of information between Ukraine and Russia anytime soon. Mr. Terentyev, many thanks for finding the time and talking to us. This was Volodymyr Sulhuk for Ukraine Today, together with the chairman of the Anti-Monopoly Committee of Ukraine, Mr. Yuriy Terentyev. Thank you for watching us.